Okay, good evening. We're going to go ahead and call the meeting to order. My name is Chris Campany. I'm the chair of the Nuclear Decommissioning Citizens Advisory Panel. Welcome. Glad to have folk here this evening, and thank you for bearing with us as we had to cancel the meeting last week. I'll start at this end. We'll do introductions.
Michael Root, I represent the town of Vernon.
Bob Leach, appointed by the governor.
Bill Irwin from the Vermont Department of Health, representing the Agency of Human Services.
Derek Jordan, citizen member appointed by the Speaker of the House.
Peter Walk, Deputy Secretary of the Agency of Natural Resources.
Chris Campany, Wyndham Regional Commission.
Lissa Weinman, citizen appointee from Senate Pro Tem Tim Ash.
Corey Daniels, I'm with NorthStar. I'm the Independent Spent Fuel Installation Manager.
David Pearson, Vice President of NorthStar.
Allison Wanup with the Vermont Department of Public Service.
Jordan Gonda with the Agency of Natural Resources.
Justin Colbert with the Attorney General's Office.
Do you want to tell us who's on the phone?
And folks who are on the line, if you would care to speak up, Bob, go ahead.
Yeah, Bob Gustafson, New Hampshire Homeland Security Emergency Management.
Anybody else?
Anyone else on from the panel? Guests, if you care to identify yourself, go ahead.
So just Bob? Okay.
I guess so.
Okay, and I got a text from Commissioner Tierney about 8 minutes ago that she is 10 minutes out. So we'll go ahead and get started. Let's see, Tony, pop quiz. How many do we need for a quorum?
We need 10.
Okay.
And by my count right
Yep.
now, I think that's what we have.
Okay. So can I get a motion to approve the December 2018 minutes? Peter made a motion. Who made the second? Excellent. Okay. Any discussion? Okay, we have to do a roll call vote because we have someone on the phone. And I am looking for my checkoff sheet.
Oh, hold on.
Can you do it?
I got one here for you.
All right. I had one.
June was bringing a bunch of those.
I had one too, but okay. Corey Daniels. Aye. Okay. Let's see. Bob Gustafson.
Close enough. Aye.
Bill Irwin.
Aye.
Derek Jordan.
Aye.
Bob Leach.
Aye.
Let's see. Michael Root. Peter Walk.
Aye.
Lisa Weinman. Chris Campany. Aye. Did I miss anybody? Nope. David Pearson.
Aye.
Anybody else? Okay, the ayes have it. Thank you. The next item is NorthStar update on Vermont Yankee site decommissioning activities. I think the best thing to do is to, if you don't mind, go to the podium and speak from there, if that's okay, unless you'd prefer to sit at the table. Okay.
All right, so again, I'm Corey Daniels. I'm with NorthStar as the Independent Spent Fuel Storage Installation Senior Manager. You may remember me as the Decommissioning Director with Entergy. And if you know way back, you would remember me as a young auxiliary operator with Vermont Yankee before Entergy bought the plant too. So after 22 years, bring a lot of history and information with the site. Got a feeling I'll be doing a little more than just managing the spent fuel storage installation. But I'm in a good position to give an overview of where we're at with the site, mostly an update on the transition the activities that we're currently involved in, and then, if appropriate, answer any questions anyone might have on that information. Big picture, transition and a lot of moving parts, right? The facility itself requires significant personnel to manage. There was a component of the multi-interest purchase agreement for some of the staff to come over and become NorthStar employees, very similar to a change of control that would happen with any company, large in size, with the staff that's staying on. The number of that staff was 8 people. It doesn't seem like very much for that site. Mostly those folks have to do with the spent fuel storage installation because it will exist in perpetuity until the Department of Energy executes on removing the spent fuel. So those people are kind of the core folks that will be here for the long term. I bring that up because there are approximately 30 employees that were previous Entergy employees or long-term contractors with expertise at the site, institutional knowledge, that have been gainfully employed and will be employed by NorthStar for quite some time. In fact, that number just went up by, I believe, 8 more this week. So you can see NorthStar's intention is to get the right folks in, ensure we have the right staff for the work that's in front of us to do. That number will change over time, and the reason the core group will stay at 7, and it'll actually be a little bigger than that for a good portion of time, but it will change because one of the most important aspects is prudent management of the Nuclear Decommissioning Trust Fund, and part of the way we do that is to make sure we only have the staff necessary to do the work we're actually involved in. So I bring that up to make a couple of other points. This is the right team right now, and it will continue to be the right team, and it will continue to grow into the right team as needed. The Asphyxia Operations has a good staff. I'm pretty certain of that. I handpicked them. We have Arano, partnered with NorthStar. They're experts in vessel segmentation. They're pretty much the world-leading experts in that field. They have the equipment designed, and they've been working on the plan on how we're going to do that job, which will take about 18 months, basically since the beginning of 2017. So they're a long ways into being prepared to do that job. We have WCS, which was recently acquired by NorthStar. They are handling and transportation specialists for radiological materials. They're experts in the field. They own the facility for which most of the materials will go to. Outstanding partnership for what NorthStar is going to do here at Vermont Yankee and in the future, potentially at other facilities as they become, world-class decommissioning experts. And you got NorthStar, pretty much the country, if not one of the world's biggest deconstruction teams, expert in their field. Definitely have the right people, the right equipment, the right know-how to do the kind of dismantlement that's going to have to happen to execute this project. So the team understands the necessity and commitment to a transparent process. Everybody's been briefed on what it took to make this transaction happen. Everybody's been talking about docket 8880 and all the provisions that are in it, understand their role with respect to it. And overall, everybody knows that we have to nurture a team approach, and our strategy for decommissioning has to include all the stakeholders. And I don't mean just the people I mentioned, I mean the town, the state, the interveners that were originally somewhat opposed to whether or not this project would happen, and anybody else who's an interested party or affected by the work that we're going to do. So know that we're committed to that, and that will not change. So with that, I'll talk a little bit about one of the key aspects of what we're going to do, because it hasn't changed in mission statement. Nuclear safety, radiological safety, environmental safety, and industrial safety. All 4 of those things grade out at the same level, and they are paramount to doing this job right. If we can't do it safe, we can't do it on schedule, we can't do it on budget, and we don't do it right. So everybody understands that we will never sacrifice production for quality, and quality starts with safety. So we have a target zero approach to that, and it extends into more than just safety. It extends into basically performance. 0 accidents, 0 injuries, 0 errors. Do we believe we're going to make 0 errors? Probably not. We know a little bit better than that. This is a large project with a lot of aspects to it, but we're not going to make any big errors, and we're not going to hurt anybody if we can absolutely help it, and we're certainly going to do the job right. So when we're done, everything's finished. We stayed on target for schedule and for budget. We're process-driven. The safety and compliance is built into the system. The NorthStar processes integrated almost perfectly with what existed at the nuclear facility for rules. We've made the major changes that are required to allow that to happen. In the nuclear world, there's some motherhood components to the rules and regulations being built into the procedures and processes. Those were already in place. The NorthStar systems meet or exceed every component of what is required for that. We have adopted our procedures and our quality assurance program to meet that, and we're already starting that work. We had our first inspection this week from the Nuclear Regulatory Commission. We had an exit this morning. There was no issues or findings. They were quite impressed with the talent set that's here, and overall, they will ramp up the frequency with which they're watching what we're doing at the facility. But when we talk about some of the work we're doing, it's not insignificant work, and overall, we got our first grade, and it was a solid grade, so know that's a piece of how we're already performing. All our work is authorized through an integrated work control process, which again dovetails into the rules and regulations. And we're going to take advantage of all the contract and procurement synergies that all those different organizations I just mentioned have. So, major work that's going on. This is probably the part where most people are more interested in it anyways. We're aligning the refuel floor so we can perform that big job of vessel segmentation. That requires a few things to happen. One of them is to empty the spent fuel pool. I say that, everybody knows we already put all the spent fuel out into the spent fuel storage installation. So why isn't the pool already emptied? Well, there were 11 large racks that held approximately 3,000 bundles of spent fuel that were in that pool, and those need to come out. So we're in the process of decontaminating those. We hydrolaze them underwater. We lift them up with the reactor building crane. We clean them up until we can get them to the level where we can wrap them and bag them and put them on a truck and ship them down the road. We're in the learning phase of that right now. We just did the first rack, and we're working on the second one. We have good performance so far and excellent data. We have no expectation that project won't be successful. So we've begun that, and that's a good component of what the Nuclear Regulatory Commission was watching us do this week. A lot of material handling going on the site. A lot of big specialized boxes and equipment are coming in. Mitch Walker's in the back corner of the room. I'll dime him out a little bit. He's one of the foremen and highly experienced logistics supervisors and superintendents on the site, and he's bringing in all the equipment that we're going to need to do that work. He's integrated with all those teams and making sure he stays one step ahead of them, so all the boxes and shipping containers that we're going to need for all the things that are going to leave show up on time, get loaded correctly and safely, and leave on time. Other things we're doing. When Entergy first prepared the facility after shutdown, they were expecting to be ready to go into safe store for 60 years, which meant we laid everything up. We drained the reactor vessel, we emptied all the piping systems, we shut off and retired a whole bunch of the components. We've adjusted those plans slightly. We're now realigning all the piping and valves and components attached to the reactor vessel so we can reflood it and have a workable water volume in that vessel to do the work of the segmentation. So there's some technical component to that, and we have the right team working on it. Along with that, is some of the equipment that will have to go inside the containment area which surrounds the reactor vessel. That structure is pretty small and cramped and very complicated with all the piping and structures. We're going into that. We call that the dry well. That area is being measured and prepped. And we're looking at all the different tooling and how we're going to set it up and get it inside there so we can do that work when it's time to do it. Additionally, in the short term, while this work is happening, to make sure that all the folks we have on the site remain gainfully employed, we're looking at some of the abatement strategies for some of the other areas. Things like characterization of insulation for asbestos, looking at paint on components and equipment for removal in the event there's lead or other items in it, polyvinyl chlorides. Those characterizations are being done, and we're developing work plans to make sure we can utilize everybody who's at the site effectively.
Sir, could you please sit down?
Other than that, we're making a few minor changes to the site's configuration for access control, mostly to do with safety. There used to be a couple of different ways in and out of the facility. We're going to limit that. There's going to be a lot of large equipment traversing the site, and we're going to have some folks at the site who may not be as familiar with the facility or the nuclear components of it doing certain jobs. We've got to ensure that the way the site's set up and the traffic flows in and out of it is well controlled. So we're looking at that from logistics and the benchmarking we've done, the other facilities who've gone through decommissioning. We're basically borrowing all their best practices to make sure they're employed here at Vermont Yankee. We've also done some work on the rail spur to refurbish it to prepare for shipments that will go out by rail. That'll eliminate a lot of vehicle traffic on the roads. It makes it safer, it makes it less expensive, and it makes it more efficient. We're looking at a couple of temporary structures that'll have to get built. We're looking at demolition of a couple of the outbuildings. We have an old cafeteria building that'll get removed. We're also looking at the best time and space and when we would take the cooling towers down. So some of those skyline changes may happen in the first couple of years as well. Along with that, some of the larger items in the facility, we'll also be looking at how we're going to get the generator out, the turbine out, the old main transformer. Some of those large components, we want them out of the way. We want them either recycled or taken for scrap, and we'll get those at our first opportunity. So the skyline changes will happen quick. Once those start, at the next meetings, we'll update people on that. We'll bring photos in, and we'll explain to them the detail of how that work is going. So I'll close out this part because I'm burning through my 10 minutes. Ultimately, we're spending a lot of time making sure we get going with everything correct and in place. There is some learning in both directions. I'll say the folks that came from NorthStar and here every day are learning from us as we're learning from them. It was a pleasure to join the 21st century with IT and electronic equipment, and instead of the way we did it for the last 20 years there at the site. So I've already seen some of the advantages of what I'll call a nimble and responsive company who's ready to make things work in an efficient manner. So with that, I don't know if Dave, you had anything to add. I'll open it up to questions if that's appropriate, Chris.
I think what we're going to do, what we've got on the agenda is we'll hear from Tony on the, I asked her to just give a summary of what happened with the NRC pre-decisional enforcement conference on Holtec, and then we're going to take questions from both of you guys.
Perfect.
Unless folk would prefer to ask questions now, Corey. So let's just do, we'll do that.
Thanks, Chris.
Appreciate it. So Tony, you are on.
Okay, I hope everyone can hear me, and bear with me with the logistics here. It's a little more peculiar than I expected. But a couple of weeks ago, Chris asked me to give a summary of the NRC's Pre-Decisional Enforcement Conference with Holtec. This was regarding two potential violations of NRC rules. So before I really get into that, I would just remind people that this presentation is for information only. It's not intended to reflect Vermont state or federal policy. And so what actually happened was the NRC conducted an inspection at Holtec International's manufacturing facilities and headquarters, and they did an audit of some documentation, including documentation that was change packages to their dry cask systems. And in doing so, they recognized that there were two potential violations of what are called Chapter 10 CFR 72.48 rules. And effectively, what those violations could be is that Holtec failed to recognize that a change that they implemented to a dry cask component was something that required NRC approval. Now, under 10 CFR Part 72.48, a licensee such as Holtec and their license for their dry cask systems is allowed to make minute changes to the design. However, in this case, the NRC is contending that they overstepped the bounds. And the second violation related to that was, since they did not recognize that they needed to discuss this with the NRC, they failed to provide the documentation to the NRC that was necessary to support the change and get the change approved or told to go back to the drawing board. This particular design change has been in the news for about a year now, and the way it initially came to light was that the components in question, which are called shim standoffs, and I'll get into that more in a few minutes, but some of the components arrived out at another decommissioning plant, San Onofre, out in California, and the components arrived damaged. There was actually at least one instance where a component was actually broken off, but there were also bent components as well, is what I am told. So what this pre-decisional enforcement conference was for, this was an opportunity for Holtec to basically describe, defend themselves against the potential violations, or to explain a little more on what happened, and also what they could also do in this case is that they could admit that these were violations, and then from there they could go on and say, well, these are the remedial actions that we have done to fix the issues brought up with the potential violations. So they took that last route. And what they did, they acknowledged that the two violations were in fact violations, and they indicated, they then went into evaluation that they had performed to demonstrate that even with the violation, it did not, and with this design change, that there was not a cause for concern in the safety of the fuel. So I'll talk about that in just a moment. But the rest of the conference is really an opportunity for Holtec to describe their corrective actions to their processes so basically a situation like this will not occur again. What is important to point out from the NRC's perspective is from the meeting back on January 9th, there was no enforcement decision made at that point. That the enforcement and the investigation process at the NRC is still ongoing. But what they did say was that they expected to have a decision within 30 to 60 days from the date of the conference. So figure February 9th, between February 9th and March 9th, we will have a decision from the NRC regarding these potential violations. So what exactly happened? And this is a top view of a multi-purpose canister, which is the can inside the overall dry cask. And this is what actually holds the fuel. So you'll notice that there's the green area. I have that noted as the fuel basket. That's where, obviously, that's where the fuel assemblies are placed. that area was not impacted by this design change or this problem with the design. Where the issue came up is the areas in blue on this slide. These are shims, and what the shims effectively are, they're spacers that are placed in to assure that the square peg that is holding the fuel, there's not a gap there that, say, later on when the fuel is being transported someplace, that maybe that fuel basket will rattle around a little bit. It's basically just filler, is the way that this was described by Holtec. And the actual design change, what had happened was, initially Holtec was, they needed these little space air gap, well, actually helium gaps at the bottom to promote cooling circulation. And initially the gaps at the bottom were basically integral legs. This was something that was cut out of the spacer material itself. And what they did with the design change is they eliminated those legs, and they created some legs that basically screwed into the bottom. And in doing so, they created an extra component which the NRC said, hey, wait a minute, have you introduced maybe some potentially new accidents or concerns here? So that's really where the questioning came up. So in response to NRC concerns, Holtec did some additional investigation, and they determined that even if these legs at the bottom of the shims were to break off and the whole shim was to drop down, there would still be sufficient helium circulation that the cooling limits for the dry cask system itself would not be violated. So there was still sufficient cooling. The NRC is still evaluating that, but this is Holtec's contention at this point. And for the rest of the presentation, or the rest of the conference, Holtec discussed how they changed their entire 10 CFR 72 evaluation process. They have attempted to make their process more robust. They have said that one of the things that they recognized was that in implementing this change, they were actually trying to improve cooling or overall the design of the multipurpose canister, but they forgot about things such as manufacturing, ease of manufacturing, and they introduced some manufacturing problems in implementing this design. So they have what they think now is a more robust process. And the other major thing that they did was, rather than sticking with the screwed-on leg design, they went back to the original design too. So from the Vermont Yankees perspective, VY did receive some multi-purpose canisters that had these screw-in legs as well. When the issue first came to light last March, Vermont Yankee did take an extensive program to look at the MPC components as much as they could, and they did not see similar damage to what was seen out at San Onofre. Moreover, since the major concern with this design change was maybe it was reducing the overall cooling, one thing that VY pointed out was that, well, they were loading their multipurpose canisters to a lower heat load than what was specified for the MPCs themselves. So there's some additional margin as well. And Holtec also determined that there were no seismic concerns for fuel storage with this change. So that's about all I have on this presentation right now, other than to note that if the NRC accepts everything that Holtec has described, all of those results would apply to Vermont Yankee as well.
Thank you, Tony. So now, first we'll have questions from the panel for Corey or Tony.
I'll go. Tony, so the casks that are at VY, the Holtec casks, they have the new design?
There are some that have the new design. Those were inspected as much as possible, and there was no indication of similar concerns that were brought up at San Onofre. In other words, they found no broken shim standoffs or the little legs. And there was just what was received by VY was in much better shape than what was received at San Onofre.
But basically the casks that, how many of them are the new design? Do you know? I mean, it's a...
I don't have an exact number on that. I don't know, maybe Corey, you have that? Okay, terrific.
I'm just wondering, so basically we have some casks that were not, or the design was not approved by the NRC or was subsequently approved by the NRC. It sounds like they withdrew that design and returned to the old design, but we've got some casks with that new design that had not been approved. I'm not saying that necessarily is an issue, but I just wanted to know how many there are and if that's the case.
So if I understand the question, it's how many casks at Vermont Yankee had the design with the shim standoff instead of the monolithic shim. There are 35 casks at Vermont Yankee. And if I may add to that, the design approval component, I'm not sure it's accurate the way you just stated it. I mean, we got to wait for what the NRC determines. There is a screening process for that 10 CFR 7248, and the apparent violation that is being determined, and we're waiting for the results after that hearing that Tony described, is to decide if they applied that screening process appropriately. So whether the designer approved or not is kind of a different question or statement.
Derek?
Yeah. I had a question for Corey. Corey, it was about the spent fuel pool racks that you were talking about. You said that you're removing them now and for eventual transport. Do you know where they're going to be going when they're sent?
Yes, I do. They will go to Texas.
Texas, and which facility there? Do you know?
At WCS.
WCS. Can you tell me, do you think they'll go by rail or truck?
It could be a combination of both. The intention is to go by truck.
Yeah. Is there a schedule for that at this point, or?
There is a schedule.
For transport?
It's still being fully developed based on how quickly we can decontaminate, package, and prepare to move them.
In your estimate, how soon do you think they might travel?
If it goes the way we want it to go, they'll be there in the next month or two.
Okay. All right. All of the racks, you mean? Yes. Okay, thank you.
Any other panelists have any questions? Bill?
Yeah, thanks. Just had a question for Tony. I'm trying to understand this green bullet on the slide here. Holtec's subsequent evaluations, if accepted by the NRC, would apply to the dry cask. Does that mean that there might be some additional inspections required, or what does that mean, subsequent evaluations?
I was referring to the evaluations that Holtec made after the issue had come up. There may be some additional questions from the NRC. They were fairly clear, though, that they did not see an immediate safety concern. However, they did note that they could request more work from Holtec.
Okay. And if I could add another question, and that's actually for Corey. You were talking about material handling, and sounded like you were removing materials from site as they were cleared. Is that correct?
No, I apologize if that
I may have misunderstood. It's okay.
was what it sounded like. What I mean is we're basically lifting these large components out of the pool, putting them in what we call super sacks, and staging them in preparation for transport. Material handling in itself is, inherently a significant operation, especially when you're using large contaminated or radioactive components.
Right. And follow up to you mentioned scheduling. Did you think that as you get to future presentations, you might be able to share a schedule of upcoming evolutions so we could have a sense of what kind of things we'll be seeing in the coming weeks or months, things like that?
Absolutely.
Great, thank you.
Any other panelists? Hold on, let me see if there's anybody else. Okay, Lisa?
So just to be clear on this, just the Cask thing. So Holtec withdrew the design, so they're no longer making that design on the Cask. But VY has 35 of them, and the NRC is still deciding whether or not they conform to all its regulations. Is that right? Is there a possibility that those casks might need to be changed? Yeah.
So Holtec did not withdraw their design, as I understand it, and I was on the same 4.5-hour phone call that Tony's describing. What they did do was revisit the 7248 evaluation, and as Tony explained, changes, and I won't call them minute changes, changes can be made to the design of a component that falls under the purview of the control of the NRC, as long as there is no reduction in safety for those components. And that's kind of what that screening process does. I believe what Tony was describing is Holtec, in fact, performed an additional 7248 evaluation to explain the design to better meet the NRC's query and charge that they may not have done that screening process right. If you screen a design change and it doesn't meet the requirements to ask the NRC for approval for the change, you can make it without their approval. So that's what's occurring right now. But back to your question and what Tony was trying to explain, I believe, and Tony, feel free to correct me if I misspeak on your behalf, was that the design, the 7248 evaluation that Holtec is reperforming and submitting to the NRC does in fact also apply to the Cask at Vermont Yankee that have the shim standoff. That's all he was saying.
Okay. All right,
And
Yes,
I would-
and that's accurate. What was the meeting itself focused on what went wrong in the assessment process. Separately, any potential safety concerns with the casks, or maybe that the casks have to be changed, or I should say the MPCs have to be changed out. The NRC is satisfied that there is no immediate safety concern with those.
Okay, any other questions from panelists? Corey?
I have one for Tony, and maybe it's not so much a question as I just wanted to add a little bit of information to that, so I can either phrase it in the form of a question for Tony or I can just share it. All right, so my understanding and the information I have from the beginning and knowing about the Ice Storm 100 system and the Holtec Cask and the design change that occurred, and I cannot speak on behalf of Holtec, but my knowledge and my belief is not only do the shim standoffs, because we have such low heat load fuel loaded in our casks, wouldn't matter if they all broke according to Holtec's analysis at the VY casks that have that design. But in addition to that, in their causal analysis, in our investigation and determination of whether or not we would continue to load casks, we inspected every single one we could in every way possible with cameras remotely before we loaded them and looked for any indications. And we learned the canisters that were built for San Onofre, because they're in a saltwater environment, their fabrication process was much different. They laid those cans at an angle on their side, they rotated them a couple 100 times, and those dynamic forces during the manufacturing process Very easy to see how a small pin on the far end in the inside on the bottom of a round cylinder could get damaged. The ones that were built for Vermont Yankee and other sites that aren't in a saltwater environment don't go through that same number of rotations, that peening process. And subsequently, Holtec has made a confident claim that the construction activities for fabrication did not apply at Vermont Yankee, which is consistent with the indications from all our inspections.
Yeah, those are good points, and there's really not much more I can add to that.
Okay, now we're going to open it up to the public. If you would, come up to the podium, ask any questions, and please identify yourself.
Hi, good evening. I'm Clay Turnbull. I'm a staff person and trustee at New England Coalition on Nuclear Pollution in Brattleboro. How many of the 35 casks with the shims in use at VY were not able to be inspected because they were loaded before the shim issue became known? Do you know? Yeah. You're the only person here I can think that would know the answer to that.
I do know that number is 16.
16. Okay. That was my only question. Thank you.
Any other questions from the public? Okay, thank you. We'll move on to the next item. What I asked as chair of the different state agencies that have oversight roles was to come share with us first, what is it that the board, that the Public Utility Commission, if I call them board, I apologize, I mean the Public Utility Commission, what the Public Utility Commission order says with regard to public engagement and reporting to the public matters related to the site and site decommissioning and site restoration. And then also for the state agencies that have an oversight role in the rules and regulations that they are responsible for administering, are there any particular points of public engagement, public reporting that they go through as a matter of course? And as we hear this, I just want to go back through briefly. The reason I asked for this is this is information for the panel to think about what we do and how we do it going forward. And I'm just going to go through briefly what the duties of the panel are. And this is from our adopted charter, and the duties come from the statute. And it's to receive written reports and presentations on the decommissioning at its regular meetings. The reports received by the NDCAP address decommissioning plans, including, and it's fascinating to me because you can tell when this was written, we didn't anticipate we'd be at a decommissioning. It says all site assessments, the post-shutdown decommissioning activities report and amendments, periodic reports on a decommissioning trust fund and other funds associated with site decommissioning and or site restoration, including fund balances, expenditures made, and reimbursements received, and any progress reports on decommissioning activities by Vermont Yankee as submitted to the panel. So it's interesting because back at the time, I think we were really so focused on the PSDAR and the site assessments that we didn't really know that we'd be at this point. Also, to provide a forum for receiving public comments on Vermont Yankee decommissioning plans and reports. To provide comments on plans and reports as the panel may consider appropriate to the state agencies and the Vermont Yankee owners. To provide an annual report to the governor and energy committees of the General Assembly due January 15th of the following year. So that's what our duties are per our charter. And so I'll go ahead and turn, who wants to start first?
I will.
Okay.
Can I take that mic?
Yeah.
Hello? Hello? There we go. Hi, I'm Allison Bates-Wanup here from the Vermont Department of Public Service, and I, along with my other colleagues from the various state offices, are going to talk to you about the items that Chris discussed before, highlighting the NRC and PUC decisions, as well as our roles in the decommissioning oversight. So first we'll put up the agenda, first discussing the orders, and then each of the state agencies is going to discuss its role. So To start off, I think you're familiar with the Memorandum of Understanding, but I just wanted to review that because it flows through everything that we're going to talk about today. So that was signed on March 2nd of 2018 between NorthStar Energy, the state offices, and several interveners, including the town of Vernon and the Wyndham Regional Commission. This MOU secured financial assurances of at least $250 million, and this is in addition to the decommissioning trust funds and the spent fuel trusts. I have the most recent balances as of the end of the year. They obviously changed with the closing, and the NDT was about 498.5, and the SRT was 333, or was 33 million. And the MOU also established certain oversight rules for the various state agencies, as well as reporting requirements and information that NorthStar has to provide. The signing parties to the MOU requested that the NRC and the Vermont Public Utility Commission approve the transfer of Vermont Yankee from Energy to NorthStar. And even though each commission could have issued their decisions independent of one another, the Vermont PUC elected to wait until the NRC issued its order before it chose to issue its order. So, slide. So the orders by the Nuclear Regulatory Commission, there were actually two. They both said that they were issued on the October 11th of 2018, but then they were kind of published on the 12th, so you might see the 12th or you might see the 11th. So the primary one authorized the license transfer, and I'll talk about that in a second. There was a secondary, less substantial one that authorized NorthStar to use an exemption of $20 million at a time from the Nuclear Decommissioning Trust to pay for the cost of safely storing and transporting spent nuclear fuel. So but the primary order is the one authorizing the license transfer, and the NRC had to answer the question of whether NorthStar had the financial and technical qualifications for decommissioning and spent fuel management such that there was a reasonable assurance that the activities NorthStar will undertake will not endanger the health and safety of the public. And so in issuing their opinion, we can go to the next slide. They obviously made the conclusion that they did have the financial and technical qualifications. But I think what's interesting when you read the order is just, how much the NRC really stress tested this transaction and kicked the tires. They asked multiple times for additional information, particularly regarding spent fuel management, and they conducted their own independent cash flow analysis. And they obviously have a lot of expertise as well as resources in this area to look at this transaction. In the end, the NRC's order did not significantly modify the MOU. Its additional requirements were that there be satisfactory documentary evidence that NorthStar obtained the appropriate amount of insurance required for a licensee. Energy submitted that evidence, I believe, on the 21st of this month. They asked that NorthStar not take actions with respect to the $140 million support agreement without the NRC's prior written consent, such as voiding or canceling the support agreement. And they also had NorthStar obtain a performance bond if it does not settle with the Department of Energy issues related to the spent fuel management. But what's also important to understand is that while the NRC was focused on the financial and technical qualifications of NorthStar, they weren't looking at other aspects of the MOU, such as the roles that the state agencies would play and how that could affect the oversight. And those questions were left to the Vermont Public Utility Commission. So if we go to the next slide. So the question for the Vermont Public Utility Commission was broader, and that is whether the proposed transfer will promote the public good and the general good of the state of Vermont. And that included the same technical and financial qualification piece, but had to look at a lot of other factors that we'll go through in a minute. So on December 6th, right before the last NDCAP meeting actually, the Vermont PUC approved the transfer and the request to transfer the certificate of public good from for the Yankee plant to NorthStar. And the only added condition was for, thank you. Oh, wow, that's a lot louder. Thanks. The only added condition was for the department to review and confirm its satisfaction with the insurance and escrow documents, which we did prior to the January 11th closing of the transaction. So the commission's review was pretty comprehensive. They issued a 57-page opinion. Nearly 10 of those pages were addressed to the concerns of the Conservation Law Foundation that did not sign the MOU. So they, they took their time and they definitely wanted to do a deep dive on this. So I'm going to go through some of the important considerations for the commission. So the additional financial assurances, as well as the other risk mitigation measures in the MOU, were of critical importance for the PUC. And so I've listed the different financial assurances that were available, such as the $140 million support agreement, the SRT balance of $60 million with a contribution at closing from Energy that ended up being about $35 million, pollution legal liability insurance, the escrow. And what I think is important to note about this is how many different means these financial assurances come through. So they really do provide multiple layers of financial assurance, and that was really important to the Vermont PUC to make sure that there was enough money, in addition to the Nuclear Decommissioning Trust and the Site Restoration Trust, to complete the work that needs to be done. They also, like the NRC, looked at the technical and managerial competence of NorthStar and the conclusion of whether NorthStar will be a fair partner to the state of Vermont. And those were some of the considerations that I think Corey touched on when he was talking about the transition that's happened so far. And kind of relating to that fair partner analysis, the findings of fact numbers 124 and 125 related to NDCAP. And they noted that, NorthStar has committed to collaborate with stakeholders to establish a public engagement process and work with local citizens and the government throughout. And the fact that NorthStar had done so much to engage with the different offices of the state as well as the locals, and they'd done so in a civil and a collaborative manner, really supported the fair partner analysis from the PUC's perspective. And another huge factor, which we're all aware of, is that accelerating the time when the Yankee site can be restored was very important. And on this factor, I've included a quote from the order where, the commission recognized that there were risks at any point for the decommissioning, but there was a concern that under the SAF-STOR method with Energy's proposed status quo, these uncertainties and risks would fall on a future generation that realized no benefits of the electricity generated by Vermont Yankee. So another item that for the PUC was the state office's oversight rules. They said, and I quote, "We emphasize the importance of the post-closing oversight activities by the relevant state agencies in mitigating risks to the state related to funding adequacy." And then one of the final considerations, of which there were others though, was the broad support of the MOU among the state offices, other parties, and the public. The PUC cited the brief of the Wyndham Regional Commission and noted the WRC's support for prompt decommissioning and site restoration, and that it was consistent with the orderly development of the region here. So that was the summary of the orders, and we're going to move on to the roles of the state agencies, the state offices, and I'll talk first and then hand it over to my colleagues. So here's a summary of the general roles of each state office to be talked about in more depth. So the Department of Public Service, our general role is to exercise oversight regarding the project's progress and the financial aspects of it to hopefully confirm that the decommissioning is on time and on budget. Agency of Natural Resources oversees the non-radiological remediation and site restoration activities. The Office of the Attorney General provides legal advice to the state entities and the review of legal documents related to the financial status. The Department of Health oversees compliance with the relevant health standards and the state's oversight of radiological contaminants. So there was questions about our authorities, where the different offices get their authority from. So the department's general authority comes from Title 30 of the Vermont statutes, and you can see the link there for the statutes, sections 1 through 611 generally, but I think the most relevant one is section 2, which identifies our general powers, which include to initiate proceedings and to investigate. But really what matters is going to be driving a lot of this are the different parts of the MOU, which I'm going to discuss in a second. So public reporting and engagement, all of the public offices, as you're probably aware, are subject to the Public Records Act. That means that upon request, unless an exemption applies, they will produce something to citizens that request it. But regarding affirmative reporting obligations in the absence of a request, there's mostly what we have is in the form of legislative reports, which you can see on our website. And regarding the Public Record Act, I did want to note that Section 2J of the MOU requires NorthStar to provide any PRA or Public Record Act exempt materials in a format suitable for public disclosure. So there's something like trade secrets. Those aren't subject to the Public Records Act, but any information they're providing has to also be given to us in a format suitable for public disclosure. Section 8 of the MOU obligates NorthStar to collaborate to establish appropriate public engagement process regarding the decommissioning, and this includes forming a subcommittee for NDCAP. Otherwise, we're still in the early phases of figuring out what kinds of documents and materials will proactively make public and what kind of public engagement we can facilitate in addition to what we're already doing, which I'm going to go through on the next slide. So there's already a lot of interactions. The NDCAP statute, which is Title 18 of Vermont statutes, Section 1700, preserves a relationship between NDCAP and the department. There's also numerous other opportunities for engagement with the department. Obviously, the NDCAP meetings and the NDCAP website with the department administers. And the Consumer Affairs and Public Information Division of the department, CAPI, accepts public comments on Vermont Yankee matters, and you can see more information at the website there. And then there is the email address, psd.ndcap@vermont.gov. So our oversight role, like I mentioned, our general role is to exercise oversight to confirm the decommissioning is on task and on budget. We're hiring a financial analyst and a project analyst to aid us in those oversight. Regarding the specific regular tasks we have in the MOU, so us, along with the Agency of Natural Resources and the Attorney General, review summaries of monthly expenditures. Also, along with ANR and the AGO, we review an annual public certification, which is due by March 31st, which compares the work completed versus the work remaining, as well as the funds remaining versus the amount estimated to be required to complete the remaining work. The department will be reviewing annually financial disclosures and reports, also due by March 31st, which include financial statements for NorthStar and the Nuclear Decommissioning Trust and Site Restoration Trust balances. The department also reviews any disbursements from the Site Restoration Trust. So the department, ANR, and the Vermont Department of Health have the right to access the site, and within the terms of the MOU, NorthStar can't deny that access. Regarding the department, ANR, and the AGO have the right to inspect expenditures in the books of NorthStar entities. Then there's NorthStar is required to notify the department, Agency of Natural Resources, and the AGO within 7 days of certain adverse events, such as a draw on the support agreement or tripping a debt covenant. And there's a lot of other kind of event-based oversight that the department would do if certain events occurred. The PUC order specifically required the state offices to coordinate our monitoring and oversight activities. So on the next slide, if you want to go to that, I can give you, I realize it's probably hard to see up here, but this is a little bit of a snapshot into what we're already doing to coordinate our activities. This is basically the MOU turned into a trackable spreadsheet that puts everything in a phase based on where it would happen in the decommissioning process and which state entities over there on your right would be exercising the oversight there. And then we'll probably be building off of that a monthly spreadsheet to track what we're doing. So I'm going to hand this over to Justin now. All right, Justin from the Attorney General's office.
Hi everyone, I'm Justin Colbert from the Attorney General's office. I personally have been working on nuclear matters with my office since 2011, and I'll just explain briefly. My apologies. My apologies. Justin Colbert from the Attorney General's office, and I'll give an overview of the role that the Attorney General's office will play in decommissioning. So our authority derives from our general authority to represent the state of Vermont in all civil and criminal matters, and that means formal legal proceedings. So historically, our office has been the role in all of the legal proceedings involving the Vermont Yankee plant, including the litigation over the shutdown and the operation of the plant. That litigation ceased in 2012, and at that point, our office took a lead in proceedings at the Nuclear Regulatory Commissioning. Once the plant stopped operating, the Attorney General's office took a lead role in making sure that there was going to be adequate protections for the state of Vermont, and that took the form of our office intervening in several rulemakings at the NRC. We filed public comments with the NRC about their general decommissioning rules, and then when Entergy sought to transfer the license to NorthStar, our office took a role in intervening at the NRC again to raise concerns over the protection of public health and financial assurance. That was in 2017, and then of course, with the, with the March 2018 MOU that Allison just described, that MOU provided all of those great assurances that resolved a lot of the Attorney General's concerns, primarily the $250 million in extra financial support. So with that MOU as of 2018, the Attorney General's office supported the transfer of the license to NorthStar, and that effectively resolved our office's role in litigation. And so we supported the transfer at the Public Utility Commission, and we then withdrew our petition at the Nuclear Regulatory Commission. So that's just kind of a summary, but I want to highlight the point that we're kind of at a very nice moment in time right now where we have no pending litigation or any formal legal proceedings over the Vermont Yankee plant. And that's a very nice position to be in, but that traditionally is the role of the Attorney General, is to take legal actions on behalf of the state. And right now, there are no more pending legal proceedings that require our office to be involved. So now going forward, as far as decommissioning, our involvement will be in a few areas. One is to continue to provide legal advice to the agencies. That is an ongoing duty of the Attorney General's office. And then second, and more specific to the decommissioning, will be to review financial documents. As Allison mentioned, the MOU requires NorthStar to provide copies of all financial materials to both the Department of Public Service and the Attorney General's office independently. So the Attorney General's office will take its own independent review of financial materials to ensure consistency with the project. And then lastly is our office will make sure that if there is a need for any formal positions, both legal and public, we'll work to make sure that the state speaks as one voice. My understanding is that there'll be a process with NorthStar for the different state agencies to express their own opinions over their respective areas. For example, ANR or DPS and the Department of Health can all express opinions on the project, but to the extent there comes a time for more formal positions or a consistent position, that's when the Attorney General will take a lead and make sure that the state speaks as one voice. And then there's a link to our office's webpage just at the bottom of that slide, just to know that our office maintains its own webpage and public information about the specific areas where the Attorney General is active in the Vermont Yankee plant. Hope I didn't go too fast for folks, but I'm happy to take questions when that comes up.
Next is ANR.
Thank you. ANR's role is primarily one in non-radiological cleanup, as we've talked about before. and overall site restoration standards. We derive our authority from 10 VSA Chapter 159, as well as the mediation. I'm not even going to try to do the IROC-P. We know it as the I-Rule. It's essentially involves our cleanup of contaminated sites. Next slide. Several portions of the MOU are relevant to A&R. As I said, we're involved in we are responsible for site restoration standards. We will also be working with in consultation with the town of Vernon to approve the comprehensive site investigation. We may break the site up into different operational units to have different controls over various parts of it. We'll look at groundwater quarterly sampling plan, characterization of below-grade structures, and the demolition of building structures and filling of voids, and the use of filming materials. One very important piece is the development of corrective action plans, which we'll talk a little bit about when we get to the public engagement section. We also will be working with the Department of Health for compliance with the radiological health rule and all of the remediation of the site to residential standards unless institutional controls proposed by NorthStar and then approved by our agency. And then the development of various site protocols in terms of information sharing, site visits, and inspections. And again, we will be, with all of our other state partners, looking at various aspects of the financial methodology and understanding where different resources are going so we can ensure that the state and the town of Vernon are made whole as we work through this process. Next slide. And then, as I said, one of the big areas as we look through what we call a corrective action plan, what does the cleanup look like? How does that work? What's the timeline going to be? That's the corrective action plan. We require notice. We will provide notice to the community as well as provide an opportunity for public comment and, if needed, a hearing or multiple hearings as we go forward. All of our records, as people have talked about, are subject to the Public Records Act, and we will continue to work through NDCAP and other stakeholder processes to make sure that everybody has the information that they would like as we work through cleanup. And then again, we maintain our own website on this process so that you can help inform the public and answer questions you may have. Thank you.
It's just, again, Bill Irwin, the Vermont Department of Health, representing the positions there. Could you go to the next slide, please? So we have conducted health surveillance at and around Vermont Yankee for all of its operating history, including through the last several years of shutdown as preparation and decommissioning. And that health surveillance is described in our radiological health rule. You can look to the web page that is listed there. Tony's pointing it out nicely, thank you. That take you to that rule. And what you'll see, if you go to the next slide, please, is that we have included in our rule that all of the users of radioactive material, radiation sources in the state that include Vermont Yankee, that we would be able to obtain copies of reports furnished to the NRC related to radioactive effluent discharges, gamma radiation emanations under normal and abnormal conditions. Also, that we would have opportunities at all times to inspect and evaluate sources of radiation and the premises and facilities where sources are used or stored, making available pertinent data, records, and reports. Also, access to all records pertaining to the radiological health and safety of employees, to discharges of radioactive material and gamma radiation emanations to the environment, and to any effect of the operation of the facility upon the environment. Next slide, please. The rule also provides that licensees, registrants, provide notice of any radiological incident and reports thereof in the same manner as provided to the NRC. that we're allowed unscheduled visits to the regulated facility for the purpose of obtaining samples and surveys for analysis, that we be notified in advance of each scheduled calibration of effluent monitors so they can be witnessed, and sharing of samples of environmental media for purposes of data correlation. We've practiced this for decades, and we hope to do so in the future. Next slide, please. As with all of that other work, Health would share our findings with the public at our website to help people understand what's going on and how it may or may not impact public health. This is a graphic from our website. You can go to healthvermont.gov, go to environmental health, select radiological health, and we have a page that is devoted to Vermont Yankee, and you can see a variety of documents there, including near the middle bottom of the page, environmental surveillance and monitoring reports, as well as some contacts relative to other partners in this effort. And that's all I have for our presentation.
Yes.
Health Department has said that it will get all reports of activities or measurements, etc., and will make the public notified if they're of the reports. When the uprate was approved, it was approved with reassurance that defense line measurements for radiation from Vermont Yankee would not exceed the standards that were in place. And the Health Department and the Department of Public Service were in charge of enforcing that. And when it was found that defense line standards were being broken, were being exceeded, that the representations of the owners of the plant failed to be realized, that the public assurances that there would be no radiation in excess of the standards, when that was discovered, the public was not notified. VSNAP, the advisory panel, was not notified. The law which called for notification and a public hearing and remediation was kept within the Department of Public Service and the Health Department for months. Activities that were prohibited and the public had been granted assurance wouldn't take place were taking place. And during those months, I'm going to editorialize now, a plan was put in place where Vermont Yankee's owners went out and bought up property and moved the fences farther away from the source of radiation without announcing to the public or anyone else that the violations were taking place. And when the new fences went up, suddenly the plant was in conformance. How in this memorandum of understanding and the reassurances from the Attorney General's office can the public be assured that the Department of Public Service and the Health Department can be depended upon to report what we've just been told they would report? Where is the safeguard to see that that doesn't happen again?
Okay, so I'll allow a response to the senator, and then per the agenda, we're going to take a break and we'll come back. The panel will ask questions, and then the public will have a chance to ask questions.
Mayor. Thank you, Senator. I can't answer for the conduct of the department in the past. I can say that the representative from the Attorney General's office has made very plain that they have an independent supervisory role. So I would imagine that if my department, and I cannot imagine that my department would engage in such conduct, but if it were to do so, I would imagine the Attorney General's office will be all over it. That is your check.
Any other response? Bill?
Just wanted to make sure that the public is aware of some of the facts associated with statements made there. The land that Senator referred to as being bought up was actually owned by Entergy at the time. It was not purchased. They just moved the fence to where their land was, not to where the fence was put inside of their property boundaries. The second point is that the report, the investigation into the site boundary dose was all published in a report. If you go to the website that I have showing up there on the screen, you can actually look at the report. The report was published for the public and handed out. We actually had hearings here, and we had what was called the Vermont State Nuclear Advisory Panel hearings about that issue numerous times. So glad to talk to anyone that has any questions about any of the findings of fact related to that investigation.
Madam, as a member of the Vermont Nuclear Advisory Panel during that time period, there were fences, and at those fences there were monitoring devices, and there were fence line measurements which were exceeded, and the Vermont Nuclear Advisory Panel was informed that there were violations months after those violations had taken place. And I would take the recommendation to go back and take a look at that and see that indeed the violations were not made public, fences were moved, and the higher levels of radiation which the public had been assured were not going to take place were permitted. And that's what happened. And I say that as a member of VSNAP, the panel. The commissioner was not the commissioner at the time. I believe Dr. Irwin was representing the state at that time. And if one is interested in going back to look at the records, that's what happened. How are we going to see that that doesn't happen again, or a similar thing this time? Who's the fail-safe?
Senator, I think I've answered that question already, and I appreciate your acknowledging that this conduct that you allege about the department's past acts was not something that happened on my watch. I do think the Attorney General's office is more than capable of serving as a check on either of these agencies, and their role to do so, as you've heard from the representative tonight, is, in their view at least, embodied in the MOU. So I think you have those assurances, and I don't think they get any better than that. The AGO is a pretty high standard, I think. Don't you?
No, I don't.
You don't think the AGO is going to supervise the state agencies?
Excuse me?
You don't think the AGO is going to supervise the state agencies when they have duties under the MOU to do so?
This system failed in the past.
That's sure, but this new check here did not exist in the past.
Well, thank you. I will take the representation now, and I have another question later about the financial assurances, which are...
Okay, we're now going to break, and we will reconvene at, let's call it 7:35. All right, so what we're now going to do is based on what we just heard, and first I want to say thanks to the state agencies. You did exactly what I hoped you would do. We'll take questions from panelists. What I'm going to ask is, for the purpose of BCTV, if the folk answering questions would please answer the questions from the podium up here or from the table at a mic, one or the other, because they've got the sound adjusted for that. I'd appreciate it. So we're going to do this in an orderly manner. I'm going to begin with, we'll see who wants to ask questions. It's okay to ask a follow-up question, but I want to make sure that all panelists who have questions get a chance to ask. So who would like to start off with the first question? Senator?
In the presentation, I think Ms.
Juana.
Sort of got to the heart of the matter when she characterized what the issues here were about, and about protecting future generations from liability and risk. And that's always a tough one. The risk that, according to in the report here, is that if we delay decommissioning, that there's a risk that future generations will end up bearing the cost for a cleanup. So my question is, what is the tipping point, and who is authorized when they review the finances of how much money's being spent, how much there is in the decommissioning fund, in the extra assurances, in the bonds of the backup bonds? If it appears, if the numbers appear that more money is being spent to clean this up, and there isn't going to be enough money to finish the job, and the point is reached where that is a issue and a crisis, what's the remedy at that point?
Who would like to answer?
I'll take that. So one of the things to remember from the PUC's order was that they hoped that the oversight roles by the state agencies would nip anything in the bud. You know, we're reviewing issues monthly before anything became a crisis. But if it looked at any point like the money was not available, the department would have the authority to initiate a proceeding regarding regarding NorthStar not being in compliance with the conditions of the MOU and the CPG. And there was another point I wanted to note, that another issue that was important to the PUC that we haven't really touched on is the fact that the transaction is structured in a way that NorthStar's incentives align ideally with the states and Yankees incentives, because they have a pay item disbursement schedule where they're only paid for a certain amount of work when they complete it, and they have a margin that is built into that of 10%. And that is structured so that it hopefully aligns their incentives to stay on task and on budget. And as we all know, part of the other incentive for NorthStar is that they hope that this can be their business model going forward. So while those are baked into the MOU, there are additional layers of assurances.
And everyone in this room hopes that all of those things come to pass. My question is, should they not come to pass, should it be more expensive and less is being removed than we all hope would be removed, and it appears that the money's going to run out and there will be quite a bit left, who has the authority to act, and where would the money come from in this circumstance?
Well, I can say who has the authority to act, which would be the department, first and foremost. As to where the money would come from, I can't speculate. It would depend on the circumstances, but, a theory would be that under such a situation, you would still be able to hopefully halt the decommissioning and allow the remaining pool of money to grow over time to then alleviate to then continue the site restoration, decommissioning, whatever was left at that time when the pool of money grew. But I'm kind of at this point speculating.
I have a related question.
That sounds like a perfectly reasonable thing to have happen. If it appears the money's going to go out, it shall be halted, the money can grow, and it will get cleaned up at a later date. Who has the authority, and where is it in the MOU, Who has the authority to make that decision?
Hey, Senator, I think that's a question of law, and that's the PUC's ongoing supervisory authority. The scenario you've described also describes a failure of the anticipated decommissioning process, which has been authorized by a CPG issued by the PUC. So ultimately, the authority over that would belong with the PUC. To the extent that it intersects at all with NRC authority, I would expect that the AGO, in consultation with the Department of Public Service, would go to the NRC to seek whatever federal intervention was necessary.
So that is perfectly reasonable solution. Does the PUC have to get approval from the NRC at that point, or can you?
This is a question.
Can it be preempted?
This is a question of jurisdiction and preemption. And as you know, I'm retired from the practice of law, so I should not go any farther except to say that the PUC is clearly empowered to do those things within its jurisdiction. And when it comes to administering that decommissioning fund, the same jurisdiction that they exercise in approving this transaction is what they would exercise over that decommissioning fund. To the extent that there are aspects of it that are under federal regulation or jurisdiction, I will defer to the capable attorneys to the right of you who can opine on that. I don't think they'd want to opine on the fly here, but the NRC would have jurisdiction over that, and then they'd have to go to there.
Okay. Do we have documentation
Senator,
from the NRC that the plan, should things go awry, that shall take, we have the authority to make that take place? Because the last several times when decisions have been made about future operations, we have been told we have the authority, and then we've been taken to court one time and been overturned. On another time, we had violations of defense line stuff, and they were found to be okay. Has the NRC said that if the money looks like it isn't going out, Vermont has the authority to make this decision? Or are they saying, we'll cross that bridge when we get to it?
I can't answer that question except to say I don't think it is the way to think about this. I think the way to think about this is there is a fund that has been seeded with ratepayer dollars that was paid under the jurisdiction of the PUC. And you and your colleagues have made very clear in Title 30 that the department is to advocate for the use of that decommissioning fund in certain ways. And that in turn reflects that it is also within the PUC's jurisdiction to make decisions about that advocacy. To the extent that we're talking about anything beyond that that is under the NRC's jurisdiction, I can't say that the NRC has issued a ruling that would satisfy your questions this evening, but perhaps the attorney sitting to the right of you could follow up with you after the NDCAP meeting.
I'm going to take questions from other panelists now. I know you don't want to dominate to the exclusion of other
Thank you very much. And
who else has questions?
This is for Department of Public Service. You mentioned that you'd be hiring a financial analyst and also a nuclear project expert. I'm just wondering if those folks have been hired, if there's a price tag associated with that, and if the NDCAP panel moving forward would be able to have access to testimony from those people potentially too?
They've not been hired. We're just beginning the review process. We received 4 responses to requests for proposals, and we're reviewing those now. Some had price tags in there, and then other ones didn't, and we'll be asking for that and follow up. Regarding testimony, that's not, I hadn't thought of that yet, so I guess I'd have to confer internally and get back on that.
I would add to that, I don't see why we couldn't make them available.
Yeah.
I'm sure NorthStar will be happy to pay the bill for that.
Yeah, and I can also say that they are very excited about having their hats in the ring and expressed a desire to come to Vermont to tell us why we should pick them. They all did, so yeah.
So I have a question. One of the reporting requirements, I think that's in the MOU, but I'm not sure, isn't there a requirement that if NorthStar discovers something that is either going to complicate the decommissioning or change the cost or something like that, it doesn't have to be reported to the state within 7 days?
Yes, that's in section 2, I think C perhaps. What?
2G, the
Two-
adverse event.
Yeah, 2G, adverse event. And that was what I touched on, and I didn't have the exact site to the MOU, but that includes the conditions of if there were a draw on the support agreement or an adverse event that could have a financial impact of over $2 million, those kind of things, yes.
Other questions? Other questions?
This is for A&R. Just, could you elaborate a little bit more on the comprehensive site investigation, the process of, we had the old PSDAR report that did a site characterization, and then we didn't have anything after that. When there was a sale, it was ruled we didn't need that. What will that entail?
I'm going to ask my colleague Jordan Ganda, who's sitting at that end of the table, who's gone through a lot of the details. We'll go through that answer for you.
Hi. So the site investigation will basically be a close look at the materials or contamination that's on site that will need to be remediated throughout the process. So as Peter mentioned in the outset of our part of the slides, that A&R is focused on non-radiological contamination. So that will be an investigation of the site to identify hazardous materials, solid wastes, things like that, build contamination in building materials, and that will help inform the corrective action plan and the set of remedial activities that will need to take place as part of the cleanup. So the site investigation is really kind of the first phase. What's out there? What will we need to address through remediation? And the second major phase will be coming up with a plan to implement the remediation and then actually implementing the remediation. So the detail in the MOU outlines the timeline for the preparation and submission of a site investigation work plan. And I believe the timeline is within 60 days of the date of the sale. So we're looking at March timeframe. And based on what's still currently at the site now in terms of infrastructure, we have, and A&R has allowed this at other sites too, if it makes more sense to time the investigation and remediation on a phased approach. For instance, there are buildings still on site that won't come down right away. If it makes sense to look at those parts of the site at a later time frame or on a phased approach, we've allowed that in the MOU to allow there to be appropriate flexibility in when the investigation will take place. That's a general gist. Do you have any more specific questions?
I would just hope that since A&R is coming to our regular NDCAP meetings, that be something that was offered at the next meeting. What's going on with that? Because that's very important information. But that's only non-radiological for A&R. What about assessment of radiological conditions at the time? Is that something the Department of Health is also part of a site characterization, or do you feel that you already have that information?
At the time that the post-shutdown decommissioning activities report was submitted a few years ago by Entergy, and subsequently, we've always asked that there be additional site characterization, that there would be opportunities for us to have a look at data that may have actually come from new investigations on site, like to actually get some borings out of the ground and maybe some surveys above ground, et cetera. And we expect that may be a part of the next phase, working with NorthStar on these protocol to try and obtain better understanding of what's there and what is going to be done in the future.
And the groundwater sampling that A&R is doing, that's also non-radiological.
So the site investigation, as part of the report, NorthStar will have to submit a groundwater sampling plan. So it's actually NorthStar that's going to be coming up with the plan. A&R will be able to review and approve that plan. So we'll be able to, our technical folks will be able to review for instance, where the monitoring wells are, which monitoring wells are going to be tested, the constituents are going to be tested for. I don't know at this point what will be in that plan in terms of radiological components. So that's something I would imagine that the health department would coordinate the review of. But specifically within ANR's jurisdiction, we are interested in the non-radiological constituents and how to either mitigate or treat those in media.
I have a couple of procedural questions. So I know that the annual disclosure is due March 31st. Will there be will there be a report this year?
I believe so. Yeah, my understanding is yes.
Okay. And do you have any sense about the review role, or is it? I think that's the term they use. Do you have any sense about how long it'll take the state agencies to process the report? The reason I'm asking is, and we don't have to resolve this right now, but that to me that might we could talk about that. That might determine when we next meet. Because I think we need, like, realistically, I would think you guys would want a month at least. So we don't have to figure this out right this minute, but it's just something for us to ponder as we continue the Q&A. Does that look like late April, or instead does that look like sometime in May? Yeah. To give time to process that report? I know it's the initial one, and I'm not talking about this initial report setting the precedent for everything else going forward, but it's just something for us to ponder.
Yeah, and thanks for raising that, because it's a good question to ask as we interview the RFP respondents. So I can get back to you on that.
Okay, any other questions before we turn it over to the public for questions? Okay, thank you very much. Public, if you would please.
I would like to ask another question. I'm also perfectly willing to let the public go first, but I have a couple more. But
Are they brief or are they extensive?
When the public's done, no.
Okay. Yeah. So we'll go to the public. If you would please go to the podium and state your name when you ask your question.
Hi, Clay Turnbull again. Mr. Walk, you said that a CAP would require notice and I think opportunity for the public. Can you say describe when that happens?
You mean in terms of when in the process relative to where we are now?
Yes.
Okay,
or
so
just when would one expect to see a notice?
I think that it depends to some extent on how the investigation and characterization work goes, because this is the plan that will define what we do with what's found. Mm-hmm. And so to some extent we won't know what that timeline will look like until we know what is found. Does that make sense? Yeah. But certainly as I think Ms. Weidman said, it would be great for us to be able to update it at this meeting, sort of what is happening and when those milestones are coming. And I think that will give us plenty of lead time in order to be able to have that discussion well in advance so people know that opportunity for public comment is available to them.
Okay, great. Second question, I'm not sure I think it's to everyone on the panel, I'm not sure. Because soil and groundwater radiological contamination could be such a big driver of finances to deal with. I don't think we yet understand the extent of contamination from past leaks that we know about. Who on the panel would be watching for that kind of radiological contamination and reporting and?
Well, obviously, NorthStar will be, as well as I would assume the Nuclear Regulatory Commission, but they're not on the panel, and the Health Department.
And you would get the reports.
Yeah, and we haven't worked out the details of how we would do it, but the MOU describes that we'll be able to look at published documents as well as to obtain our own samples. So we would use the radiological health rule to try to make sure that as evolutions occurred there, that we were able to evaluate any groundwater effects for radiological contaminants. We may be able to combine that with the work of ANR with regard to non-radiological contaminants, sharing samples there, for example.
Great, thank you.
Any other questions from the public?
Hi, I'm Skylar Gould. I am the former president of New England Coalition. I emphasize the former. I in no way represent New England Coalition anymore at this point. There was an elaboration on the fact that information received by the state on the various aspects of the decommissioning will be made available. Is there a mechanism for this in place? I mean, so there are many no doubt going to be many reports and reams of data analysis and data and the analysis of that data. I'm just wondering how can the public expect to get that information if they so desire to see it?
Yeah, it's a good question, and we're still working out the details right now. ANR has their Vermont Yankee nuclear decommissioning site, and there's a question of if we'll just post things on there, or if we would create another subpage on the Public Service Department site. So, we intend to proactively make it, the annual public certification is that it should be public, and so we're just working out what's the best way to do it, if we would even post it on maybe the NDCAP site. So.
Other than proprietary information, is there any information that is committed to the state that will not be available to the general public?
Things that would be exempt under the Public Records Act that would be then made available in a format that's suitable for public disclosure.
Okay. Yeah, I did understand that. Regarding, I'm sorry.
Sorry, he just said, for example, and I started responding as if it had been your question. So, sorry, like trade secrets and proprietary information.
Yes, I understand.
Yeah.
So. Regarding the public engagement process that's mentioned in the Memorandum of Understanding, does the NDCAP charter entertain such a process, and does it have the authority to actually convene such an oversight panel? And is it understood at this point how that panel is going to be convened and under what strictures?
I don't think so. I mean, our chart, we're an advisory role.
Right.
I don't think we can require reporting. Commissioner Tierney, I don't know if you want to offer up.
I asked because it mentioned NDCAP in that, and it's been some question.
That's the point. One of the agenda items is reconvening the Issues Committee, and part of that is having a conversation about what the board order says should happen, and also just the panel's not yet had a discussion even among itself. It's one of the reasons I wanted to just kind of have this initial information put out there today about what the different reporting requirements are. We're going into a completely different phase now with Vermont Yankee. It's a much more, I would say, relatively prescribed phase that we're going into relative to a lot of the other conversations we've had as a panel. So I think that's one of the ideas is to reconvene the Issues Committee, which are also open to, those meetings are also open to the public, to have a discussion about what does it look like as the panel goes forward, how do we best engage the public, given what the different reporting requirements are, what does that look like? And the idea is that committee would then bring those ideas back to the panel for discussion. But right now, I think we're still in a state of evolution because we've not even had those conversations among ourselves yet.
So that public engagement process, it sounds like it is not necessarily going to be engaged by NDCAP.
To answer the question, if you look at the presentation materials on page 7, there's a reference in the slide that is at the lower part of the page, bullet item subpoint 2 of the first, or the second bullet item. It references paragraph 8 of the MOU. And as I read it here, NorthStar is obligated to collaborate to establish a public engagement process. It says that could include the formation of a subcommittee at NDCAP, that would be explored. And what the chair is saying is NDCAP itself right now is going through an evolution to figure out what its life will be separate and apart from this particular transaction, because NDCAP's created by statute, as you know, for the purposes embodied in the statute. So it is possible that NDCAP could choose to form this subcommittee, and that could be the thing that is deemed to satisfy the MOU, but that hasn't been resolved yet. That said, it's noteworthy that the MOU specifically obligates NorthStar to have an engagement process with the public. So if the NDCAP subcommittee did not become that means of meeting the obligation, my understanding would be that the company would be obliged to do some other form of public engagement. I hope that answers your concerns.
So obviously the company NorthStar hasn't engaged with the panel on this particular issue.
Correct. I mean, if you trace the chronology here for a moment, this transaction was approved in early December. So up to that point, I think it's fair to say that there was a question as to whether the transaction would in fact come to pass. And so a lot of things have been in a holding pattern until that order was issued. And I think this is one of those. But my own experience in dealing with the company leading up to the MOU was that it's very much engaged. It wants to meet its obligations. It wants to be forthright. It wants to be mindful and honor the public sentiment that it encounters. So I think you can have confidence that they will put serious effort into this provision. And if they don't, I'm sure you will let me know. And you can be sure I will make sure.
I believe they do.
They do. I believe they do too. But, you know, they're meeting the sheriff, and right now everything's in a honeymoon phase, and I hope it'll stay there.
Yeah. So obviously,
Skylar, I need to see if other people want to have a chance to get up before the microphone.
yeah.
I need to see if other people want to have a chance.
Sure.
To get up. So,
can I come back?
Wait, just 1 second. Does anybody else want to speak? Okay, go ahead, Skylar. Why don't you go first, and we'll have Skylar come back up. Okay.
In this ongoing oversight process by the various agencies, particularly A&R, will, for instance, the results of the site investigation or similar kind of milestone activities, will those be summarized in any kind of, will they be summarized for public consumption, or will it be a matter of, you know, publishing all the charts and whatnot on the site?
I think that's a question related to your previous question, right? What does the public engagement process look like? It's not useful if it doesn't engage the public in a meaningful way. And so I think those are pieces that we need to work through.
Yeah, fair enough.
Skylar?
Yeah.
We have another person with a question.
Yeah, okay.
Thanks. Next.
Good evening. Thank you, Mr. Chairman. John Tuthill from Ackworth, New Hampshire. My question's also on site characterization and going back before the transaction, and then a question on the corrective action plan and the site investigation plan after the transaction. I'm wondering if A&R and the Department of Health have a handle on the volume of material that has left the site since closure several years ago, either for disposal, storage, or reuse, or managed as a radioactive waste stream. That's the first question. The second is whether after the transaction, and as we wait for a site investigation plan and a corrective action plan to be brought forward and approved, whether materials will be held on site until those documents are in place. In other words, will there continue to be shipments off-site of non-radiological material, either for scrap or fill or for disposal? Thank you.
Who would like to answer?
I'm sorry, I had a hard time hearing. The first question was
Whether Agency of Natural Resources and the Department of Health have an estimate of the volume of material that has left the site pre-transaction and since closure for disposal, storage, or reuse. And just to give you a particular, for example, the building that was used for low-level radioactive storage and management was removed fairly shortly after the closure.
Is that the North Warehouse that you're talking about?
I don't know.
So I am speaking on behalf of my division, my technical folks. They do receive manifests of shipments of certain types of waste. So my division would receive copies of manifests of non-radiological hazardous waste that's being shipped off-site. So anything, and that's due to Entergy's former status as a hazardous waste generator, so we would receive copies of those reports. As to other types of materials, if it's something that's intact and not considered a waste, I'm not sure that we would receive those specifically. And your second question was, I don't know if the Department of Health is receiving similar copies of manifests or notifications of shipments of other types of waste.
Yes, specifically the health department by rule requires any shipments of radioactive materials through the state that we be notified of those. And so Entergy and then now NorthStar has and will continue to send us notice that they are shipping waste, and that waste is generally characterized. It's liquid waste in a tanker of this volume, or it's solid waste with certain activity. We know about the radioactivity, the amounts. The NRC and for the agents, the Department of Transportation is actually the agency having jurisdiction for the specific values of radioactivity by radionuclide, and NorthStar, and before that Entergy, had to share those kinds of manifests with the NRC, and they have that, and it is something that we could investigate, but because we're getting notified of the shipment itself, its transport, we've been generally satisfied with that. I also do make periodic inspections of the site, and I see a lot of the things as they transpire or that have transpired or that they're making plans, and for that reason I ask questions and generally get answers that satisfy my interest in what's happening there relative to radiological materials, radioactive waste disposal being one of them. The final thing is that both Public Service Department and the Agency of Natural Resources and the Department of Health work together with regard to low-level radioactive waste disposal. So we do get estimates of the total volume every year of radioactive waste that is disposed of, the radionuclides in those wastes, the total activity, and actually it all goes to the point of assigning costs from the waste disposal site to Entergy or NorthStar.
Thank you. I'll be very quick, but the other part of this question has to do with what happens now with the corrective action plan and the site investigation plan currently being developed prior to approval, and whether or not materials will continue to leave the site during this 60-day period. My concern is not so much the radioactive side as the boundary between the radioactive, the non-radioactive, the hazardous materials, and the solid waste and scrap materials, and how those are going to be managed on site, and who is making those decisions, and that those decisions be made in a transparent way and records be kept. Thank you.
Thank you. Any other responses to his last statement or question or anything? Okay. So we're going to move on to and there were going to be other opportunities for public comment at the end of the meeting. We're going to move on to the finalization and approval of the annual report to the legislature. What I would ask is that we have a motion to finalize and approve, or to approve the annual report to the legislature, and a second, and then we'll open it up to discussion.
So may I ask the questions I was going to ask before this? 'Cause one of the members of the public asked a question about the future of this panel, and I was asked what my opinion was on the future of this panel, and I said, I don't know. I'm going to the meeting this week, and I'll come back, and leadership wanted to know what this panel whether it would continue to exist or not. And if I may, this panel was, I think, properly constituted to represent the local communities. And because this is where the plant is and their interests, they wanted to be represented appropriately. There are three questions that have to be answered. One is safety, and that's we have no authority over that. That's the NRC, and they make those decisions. So the two things that are left is it a good thing to spend the money we have now to try and get it cleaned up as soon as possible, and with a risk possibly of it not all working out? And the people in this area go, by golly, it is. We want that money spent here. It's good jobs, it's cleaning the place up, it's good economic development, it's the best thing to do. And the last question is, if things don't work out, who's left holding the bag? And that's what it's been to begin with. If I lived here, my priority would be spend the money here. Do it now. It's good for our schools, it's good for our neighbors, it's good for our kids, et cetera, et cetera. And if it doesn't go well, someone else will be holding the bag, and we'll worry about that if that happens. In the unlikely event that happens. I represent the state. I may not be typical of everybody out there, but the state is more concerned about if things don't go well, who's left holding the bag? And that's more important, to have that question answered before the economic activity starts here that everybody in these towns would like to see happen. And when I go back, I'm going to say, when I ask that question, the commissioner correctly says, well, that's a matter of law. Answering that question is a matter of law. Well, if the money's runs out, and you go to NorthStar, and they don't have any money, they go, oh, we're sorry, we don't have any money, we're going to file for bankruptcy. And then someone would say, well, we'll go to Energy. And Energy say, oh no, we're out of here. Limited liability company. New Orleans is, you can't get to New Orleans. We're gone. We sold it. So they're not going to help with who's going to hold the bag. And
Senator, I need you to wrap this up. We need to get back on the agenda.
Okay. We've been at this since early 1970, and we're making a decision.
Sir, we've been at this for even meetings you've not attended. We've been having these discussions. I need you to wrap this up so we can get back on the agenda. Thank you.
And the chair would say the only way you can go after Entergy, the next ones up the chain, is if they knowingly knew about something and didn't disclose it. That's the only way you can get them. So they're pretty. Is that accurate, Commissioner? You're the lawyer? As a matter of law?
She can't speak to the law.
You asked for a motion on that.
Yeah, I did.
And I made that motion.
Thank you. Do we have a second?
Second.
Who was the second? Second. Great. Okay, so any discussion about the final report to the legislature, the annual report to the legislature?
No discussion, except I thank you for preparing it.
Last year, a group of us went up to the legislature to present the report. Is that going to happen again this year? And if so, when?
We need to figure that out. Let's get it approved first, and then we'll, that's the first action, and then we could figure out that schedule. And we'll probably need to communicate with the legislature to see when we can get a slot up there and who can help facilitate that for us. So, any other questions, any comments on the report itself? Bill?
Yeah, just on the page 3 of 9, line 85, there's a parenthetical statement there that I'm not sure if it's meant to stay there. regarding the discussion begins at 52 minutes and 18 seconds into the meeting recording.
Where
I think
was it again, Bill?
So it's page 3 of 9 on line 85.
Okay.
I think that was a leftover from the transcribed minutes and may not need to be there.
Page 3. Which line?
I'm sorry, yeah, it is page 3.
Yeah, I think the line in question is up on the screen right now.
Line
Bill, can you
85.
confirm that?
And see, there's a parenthetical statement. This discussion begins at 52 minutes. I don't think that's needed in the report. It looks kind of
Yeah.
silly there.
Gotcha. Okay.
Okay.
Yeah, okay.
I would just, otherwise I would strike it in the report.
Yeah,
That's fine.
that's likely a remnant of what I cut and pasted there, because I pulled from previous meeting minutes for that.
So with those two corrections, any other corrections or other comments on the report?
I'm sorry, where's the typo again?
Manner. That should be M-A-N-N-E-R.
Line 87.
Any other corrections, comments, questions?
Question.
Yes.
Will the report establish what this group's opinion is on who's left holding the bag if things don't go as planned? Or is the report saying, if that happens, we don't have an opinion and we're not going to go there?
Per statute, the report reports on the activities of the panel over this past year.
Mm-hmm. Did the panel discuss who was left holding the bag and what the panel's opinion was or thought ought to happen?
No. Any other comments on the report?
Would you please add to the report that that was a question that the committee, that the panel chose not to address? Was that fair enough?
No, because we were not asked to address it, and we did not choose to not address it. Now, a number of us who were actually parties in the discussion before the PUC raised a number of questions like this, and that was the proper venue to raise it. So now for this report, any other comments or questions? No. Okay, I'm going to ask for a vote. All those in favor, say we're going to have to do a roll call. All those in favor, we'll see. I'm going to start. Corey Daniels. Bob Gustafson.
Aye.
Bill Irwin.
Aye.
Derek Jordan. Bob Leach.
Aye.
Senator McDonald.
No, with an explanation.
Michael Root.
Aye.
Peter Walk.
Aye.
Lisa Weinman.
Aye.
David Pearson. Commissioner Tierney.
Aye.
Okay, the ayes appear to have it.
And my explanation is that in the absence of this committee making a recommendation on how to deal with who's left holding with the financial responsibility should things not work out, that our report is incomplete. Thank you.
Thank you. Okay. The next item on the agenda, so as I mentioned previously, so we will need to figure out how to get the report up. I don't know if the senator or the commissioner have any suggestions as to how to best schedule getting this to the legislature. In the past, we had we worked with Representative Dean, but he's no longer here. The question is just, usually we go through the committee chair, or one of the committee chairs that we're going to take, so whether that's going to be, it has been natural resources in the past, whether it should be energy, natural resources. I can check in with those chairs. I'm happy to do that.
And finance.
Finance too, okay.
That's jurisdiction, yeah.
Okay.
Also.
So I'm happy to reach out to the chairs of the natural resources committees. That's what we've done in the past, and we've had joint meetings.
I think this is one of those growing pains again, and our changing of the guard is making itself felt. So that sounds like a reasonable approach to me, Mr. Campany. I seem to recall there was a larger joint meeting last year.
It's House Natural Resources and Senate Natural Resources.
And I think that might be the most efficient way, and it sounds like Senate Finance would welcome an invitation too.
Okay.
So.
All right. So I will reach out to those folk and I will communicate back to the panel what's agreed upon. Is that okay?
Oh, yes.
Okay. All right, so reconstitution of the NDCAP Issues Committee. So we had an Issues Committee in the past that focused on, I tried to go back, I could not find in the minutes the precise charge, but basically it was looking at issues that the panel needed to discuss, and it would bring recommendations to the panel to begin to get the discussion going. And those issues range from agenda items, topics to be covered at agendas, and agendas to procedural questions too, procedural matters. So most of the members who were on the Issues Committee are no longer with the panel. And so we need to reconstitute it. To my mind, and I'd like to form the panel, and then the panel can begin to flesh out the agenda. But to my mind, there are a few things that we need to do. One, we need to actually, we've discussed this within the panel during the last few meetings, but we do need to revisit what the statute says about the panel and its composition. Because, like, for instance, one of the panel members is to be a member of the representative of the International Brotherhood of Electrical Workers. That's no longer relevant. Former commissioner, I guess she's still commissioner for a few more hours, Bob Buckley, was of the Department of Housing and Community Development, was wondering whether or not Agency of Commerce and Community Development still needed a role on the panel. And I'm not saying yes or no, it's just these are the kinds of things we need to bring up. And I don't think this doesn't have to be resolved immediately, but I just know that we have some basic housekeeping that we need to discuss to ultimately see how that informs statute. We have the charge from the Public Utility Commission and the board order to have the conversation about whether or not there should be a subcommittee of NDCAP to deal with the public outreach and reporting. And so we need to have that conversation. And again, it's not exclusive, it's just beginning to have that conversation, bring ideas to the panel for us to discuss. And then there are agenda item questions, and I think we'll also want to revisit, and come up with suggestions on meeting frequency, how that meeting frequency relates to the annual reporting requirements. In other words, and we've got time to do this, I think we need to get it right. The closing on the plant just took place, a couple of weeks ago. So I imagine NorthStar, now that they actually own the plant, they may have some ideas that they want to bring to the table, because they may have some of their own public reporting requirements that they want to do themselves. I know New England Coalition has said that they've been in conversations with NorthStar. They were parties to the negotiations on the MOU. They may have some ideas. They may have some conversations that they're going to have with NorthStar, and they may want to bring some ideas to us about that kind of committee, because so they're numbered. So I think we've got time to do this, but I'd like to go ahead and constitute the committee at least to begin to have these conversations, and we'll figure out who the chair of that committee will be once it's constituted. It had previously been David Andrews. So do we have any volunteers for it? Well, I guess I don't think we need necessarily a motion to reconstitute it, because it's a standing committee. It exists. So I think it's okay just to see a show of hands of folk panelists who would want to serve on it. Everybody raise their hands at once. So we got Lisa. Who else?
Two down here.
So Derek and Michael.
Bob.
No, Michael's. And Bob. And
I think you got enough. I withdraw.
What's that? Did you just withdraw?
Yeah, you got 3. I think that's enough.
There was a few. It was about 5 or 6 of us before. So.
Well.
Yeah. Sure. The more the merrier. And I would suggest that somebody from one of the state agencies, Bill had participated before. I would suggest that somebody from one of the state agencies, even if you're not necessarily a member, you may want to, somebody who has some sense about what all the different agencies are doing together and how you're organizing yourselves. I'll just put that out there. You may want to, and it could be Tony. Tony had participated before, I think.
Yeah.
But I don't know if your boss wants you to do that or not.
Can I ask that the state agencies confer and give you that name?
That'd be great.
Thanks.
That'd be great. Sure. Lisa has a question?
So I'd like to better understand, perhaps from NorthStar and NEC, what the expectation is or what the difference you perceive could be of a stakeholder panel from, in fact, what NDCAP's already doing. Do you feel, Clay, that there's a need for another body, or is that what you're contemplating? Because it seems to me from the MOU that the stakeholder panel is NDCAP. So what's the difference there? Do you feel like there's a need for another group? And if so, what would it be doing that's different than what we're already doing here?
And I just want to say as chair, Clay, you can answer that, or you can choose not to. We don't necessarily have to put you on the spot.
I think what I can say is that the MOU has some vagary in it, the way that it's written, and that allows lots of possibilities. And I think we're still exploring how to make best use of that opportunity. There are advantages to not having the constraints of such a large panel or working within the confines of public meeting law, public meeting records, this is a very formal body, and I personally envision that the effectiveness of stakeholder input might be better represented in a more fluid relationship. So I don't know if that helps.
And Corey and David, I don't know if you guys have anything that you want to add?
We understand Section 8, and we definitely want to be transparent. We're 20 days into this, so we just ask that we give it a little time for us to confer on that.
So, and that's another thing. So I'd mentioned the state, but also previously, Entergy didn't have anybody on the issues panel, but to some extent, David was aware of what was going on at the plant and is really helpful to kind of have that perspective. So if you guys want to ponder too about whether or not you might want to have somebody on this committee, I would welcome that as well.
I realize there are many opportunities for I'll say the technical aspect that I can bring and the historical knowledge where it will be very useful. So I think in a limited opportunity where it would be beneficial, I will volunteer my time as well. I know from the meetings we've had and the tour, there is a lot of collaboration, and there's a lot more this panel can probably do out into the future to help solve some of the issues and partner with other communities and similar panels that are trying to solve similar issues. So I look forward to helping with that.
Great. Well, thank you so much. So I'll get the ball rolling once we hear from the state. Commissioner Tierney has a comment.
With the departure of Ms. Buckley from the panel, she occasioned some discussion about what the proper role of state agencies is on the NDCAP. And I just wanted to share my own reflection on the point. It was brought home to me that this is a citizens panel. And so, to my mind, it makes a lot of sense for citizen curiosity to drive that issues committee, which is why you don't see my hand in the air. To me, it's always a given that I'm available as a resource for consultation, but I think my presence can be heavy-handed at times because one defaults to the state as the authority on everything, but the panel is intended to be a grassroots forum for the citizens to advise the state on what it considers to be the issues of the day. So I just wanted to make that observation, because I wouldn't want the fact that none of the state agencies have volunteered to serve on the panel to be in any way misconstrued as a lack of interest. It's rather a respect for the panel.
No, I appreciate that, and I absolutely get it. And I know it just, and this is just my own personal perspective on the state engagement. I think it's one of the great things about the panels that we have this engagement with the state agencies. But to me, actually, one of the fundamental questions we need to ask going forward is, it's awkward to advise the very agencies that are also voting to be advised on the panel. And so to me, one of the fundamental questions to be asked actually is, are the state members more appropriately ex officio members, non-voting members, as opposed to actual voting members on those being advised? And to me, that's a question that because this is what constituted a panel. A change like that would require a change to statute. So, but to me, it's just a question. And we've got time to deliberate upon that. So I appreciate your bringing it up. But I didn't take it as a slight. It was really helpful to have, where the state was really helpful in the prior issues committee discussions with both Bill and Tony. It was more bringing up the technical issues, or as the citizens who are engaging, kind of knowing, like, so what experts can we get to come talk to us about this, or where are we in this process? So they were helpful as more as resource people. And of course, the plant was too, and David Andrews, again, not representing Entergy, but representing the International Brotherhood of Electrical Workers, was really helpful in kind of providing that technical input. Any other comments, questions?
It's a given that Mr. Lashinsky is available to you for consultation.
Once again, sometimes I can't hear what's being said because the PA system is going that way.
But you can hear me volunteer you, I just know that.
Senator McDonald?
I think what is likely to happen is this, VSNAP was 7 people, I think 3 state officials and a couple of members of the legislature and a couple appointed by the governor, and they tried to take the statewide view. This panel has had a chance to exercise what it wanted to see happen here locally. And I think is probably pretty pleased with moving along more rapidly, even, and perhaps there'll be a panel that replaces this, but will often meet here. This is speculation, that tries to make sure that all the things that were hoped for come to pass, and if they don't, give some advice on how you should be chased down to someone, should the state or all of us be left holding the bag. So, but I think the commissioner would probably be the most, and the representative from the community here would probably be the best people to speak to finance, who created this committee, and would be asking what would replace it, what would be appropriate to replace it.
Okay, we're now at the public comments part of the agenda. So any general public comments for the panel that the public would like to bring to us? Skylar?
To the current discussion, is there a mechanism for representation on the Issues Committee by citizens who are not on the panel?
I don't know.
As the chair previously mentioned, it's subject to open meetings law, so you will be afforded the opportunity to be present and make comment.
To be present. Okay. So, excuse me, how does one understand when the Issues Committee meets?
It'll be advertised just as we do NDCAP meetings. We still have the mailing list. It'll be advertised just as everything else around NDCAP's been advertised. And Skylar, the reason I say I don't know the answer to your question is, in some entities, in some boards and panels and other things like that, you can have non-panel members be members of other committees or that kind of thing. I think our guidance, I think our charter and all is silent on that. But I don't know. That's why I don't want to say yes or no without going back through the charter and seeing if that option exists. But all of our meetings per open meeting law will be open to the public, and we'll be taking public comment.
Very good. And one more question. I understand that the state, I'm thinking particularly the Health Department and ANR, is able to make unannounced visits to the site during decommissioning and take samples. Is there a mechanism for any citizen to petition the state to allow them to go onto the site unannounced to take samples, since we're part of this process too?
Can you clarify that you're petitioning for us to go on and take samples, or for a member of the public to go on?
For a member of the public to take samples.
I do not believe there is a provision in the MOU nor relative to the security plan, but that would be something we'd have to look into.
And then, I mean, you stated the option of petitioning the state to go onto the site and take samples for, with cause or, with reason, not willy-nilly, obviously.
I didn't state that position. I was clarifying your question.
Okay, so I can ask this question again at a future time? I'm just wondering, is there any, what, the citizens have a right to information.
Can I just interject for a moment?
Yeah, thanks.
I am not aware of any barrier whatsoever to a citizen contacting a state agency and asking that state agency do something. So that's item one. I would imagine that you are also perfectly entitled to approach the Attorney General's office and to show the Attorney General your basis for thinking there's a need to go on the site in addition to what the state agencies are doing. I wouldn't begin to express an opinion as to whether they would actually, take the cause up or not. That would really be for Mr. I'm sorry, I've forgotten your last name all the way at the end. Justin, but...
Or the Attorney General himself.
Precisely, but the point is that the citizens in this country are able to approach their government, they must approach their government, and they have the right to petition for redress. Whether the government, ultimately does what the citizen wants is another story. But I would point out that you are talking about private property. And so there are limitations that pertain there, and I think you're probably aware of that. So I think you're asking a really good question, and the first thing to do, if that's what you think needs to be pursued, is to approach your state government and ask, hey, would you be willing to do so, and find out what their reasons are for saying yes or saying no. Does that help at all?
Yeah, sure. We'll
okay.
Consider this in the future. Thank you.
Does anybody else have a question or comment?
Good evening, everyone. I've been to some of these meetings over the years. For those of you who don't know me, my name is Ned Childs. I'm the acting president of the New England Coalition. It's my understanding that the coalition, in conjunction with the good people on this board, these comments directed at Mark, is trying to achieve a good cleanup. And that we're going to find ways, they're trying to do it in Europe now, in England, around the world, decommissioning these nuclear plants. This is just one of many boiling water reactors slated to be cleaned up. And as far as who's holding the bag, this fateful decision to build these plants here and at Oyster Bay and everywhere and around the world, the public at the end of the day is left holding the bag. If there's more massive contamination that hasn't been revealed and there are no cost-effective ways to clean it up, then we'll have to be left with a higher cleanup standard, or we'll find other monies and tax ourselves to clean this up to the levels that we feel comfortable with down the road after the $500 million has been spent. And I think we might as well confront these issues with open and clear eyes. So thank you all.
Could I make obviously this phrase holding the bag has been tossed about, and I wanted to maybe make a quick illustration regarding the financial assurances as to what it would kind of take for that actually to come to pass. So Some of the financial assurances include $140 million support agreement, as well as a $55 million escrow account. And meanwhile, on the other side, you already have a nearly $560 million in the SRT and the NDT. So you have, on one hand, an additional $200 million right off the bat compared to a $560 million decommissioning fund. So you can think of those financial assurances as over a third of that decommissioning fund. And meanwhile, on the other side, you have this pay item disbursement schedule that that is hundreds of items long, and there's a line item, a budget for every phase that goes with that, with a 10% margin for NorthStar built in. And they get paid out money based on the completion of those items. Meanwhile, the state's oversight is for those pay item disbursement line items to see how they compare as this transaction is going on. So for all of this money to be exhausted, you would have to assume that we would somehow go through, that $560 million while not noticing that each of these hundreds of line items was going over budget, with the 4 state agencies exercising oversight here. And on top of that, with that $200 million support agreement, if things are going over budget early, you can trip those to bring them into play. So I think that, the idea that you have all of these financial assurances and all of this money, and you can see the budget as it's going down, and we are exercising that oversight. I would just kind of wanted to speak up to hope that this illustrates that we can catch these issues early and we can decide how we want to proceed. And the idea of who's left holding the bag is kind of based on, assuming that all of those other fail-safes just didn't come into play. So.
Right, that's what this is about. Yep.
So we had a comment over here, and then we'll go to Bob.
It's a lot.
I'm a member of the public. That's it. And I come because for the nuclear thing is very close to me, because it just feels like such a sacrilege to the earth, and somehow it speaks to me. So I'm here trying to understand what's going on, and I have to say, I'm very honored to be able to be a public member and speak. So that's partly why I really love Vermont, that it's easy and I can be here and talk. But I do want to say that I would really appreciate a synopsis at the beginning of these. If somebody could come up and say, this is what the meeting's about, this is the issues, this is what we're presenting to you. So I'd appreciate that. It's hard to understand all this. I'm not a lawyer or anything. And I do, after listening as closely as I can, hearing about the casks, I think that's the way to say it, that there has been something found wrong with them, and yet the company that made them admits it, and that these casks they weren't all inspected, but I may get this all wrong, but as I understand it, they've been filled, and I don't know if they've been sent.
No, they haven't been sent.
But it makes me very nervous. And that they're sent to Texas, and I'm wondering what's in Texas, and so that's just why I'm here. I guess that's all I have to say.
That's the bag.
Ned, thanks. Bob?
Bob Spencer from the Town of Vernon Planning and Economic Development Commission. We had done our own due diligence on the NorthStar proposed acquisition, hired attorneys and technical people. And one of the answers to the question about holding the bag is that NorthStar genuinely believes that quite a few of their hundreds of tasks will come in under budget. And that there will be, and this is where the gravy is, and potential profits and incentives. And for us, and I'm in the engineering and solid waste industry, and I have observed many projects where we were able to implement them at lower costs than we estimated, because we want to cover our costs. So we budget high, come in under, and we get the job done. And that's in the solid waste industry. So I'm fairly confident. Our Planning Commission spent a lot of time. We obviously were really concerned about this deal. The Board of Selectmen in Vernon also very concerned. And so I just feel that we've done a very good job evaluating this at the local level, and we continue to rely on these state agencies to implement this. So I just want to say that we are holding our confidence high, but there is always a possibility that something goes wrong. So thank you to this group, and thank you to NorthStar for stepping up for something that is a huge task.
You want to comment?
Yeah, thank you very much. Betsy Williams. I live in Westminster West. I've come to a number of these meetings. And I think somebody said it earlier as well, and I want to restate that I can't imagine that there's anybody in this room or who would be in this room if they could be, who wouldn't agree that we hope that things move forward in the way that we have outlined here, and absolutely appreciate all the efforts that have gone in to try to scrutinize and have safeguards and safeguards on the safeguards. And I'm certainly no expert in this realm, but my understanding is there isn't any nuclear power plant to date that has been decommissioned within the budget that was prescribed. Is that correct? So I think that the question is one that is worthy of note, that there's reason for concern and skepticism because we have not yet experienced a decommissioning of a nuclear power plant that has stayed within budget, or even, as I understand it, anywhere even close to within budget. So things happen that are unanticipated, often dramatic things that are unanticipated. And so if that one line item that we discover, yes, we'll be discovering along the way, but if there is that one or two line items that goes 15,000 times over its budget, we have a problem, right? And not one that's not necessarily easily remedied, as far as I can tell. Yes, I'm glad that there are safeguards, and I do truly hope that NorthStar is correct in their estimate. I just want to note that there is good reason for concern in this realm. Thank you.
Any other public comment? Okay, thanks. So now we need to schedule our next meeting. I'm going to throw out, so I've already heard from Sarah Coffey, who's a new legislator, speaking up for other legislators, and we appreciate the senator making the trip down, about the difficulty of meeting on days other than Monday during the session. The last time we tried to schedule a meeting, when we last scheduled this meeting, for some reason it was difficult scheduling a meeting on a Monday. But I'm going to throw out a suggestion, which is that we meet in May, to give plenty of time to get the report out at the end of March, give those who are processing the information time to process it, develop reports that make sense to the public. And so I was going to suggest, just throw out there to start the discussion, Monday, May 20th. That's the Monday before Memorial Day. Would that work for folk? Senator, I know you don't have a crystal ball, but when does the session typically end?
When you don't expect it to end.
Okay. But I forget, is it typically going well into May?
Usually around the 10th of May. This year was the latest start.
Right.
That's a good date.
May 20th? Okay.
Good
all right.
guess.
So does that day not work for anyone? Okay, so let's say May 20th. We'll let you know what the venues, we'll let you know what the venue will be. And the time, though, will be 6 o'clock. And I think the primary discussion, so we'll convene the Issues Committee before that meeting. So I'm thinking through just some general agenda topics, but obviously there will be the initial reporting out. If the state agencies and NorthStar feel like NDCAP is a proper venue to perhaps do a public reporting out of that May 31st information, is that okay? Well, the March 31st is when but if you feel like I was making an assumption, I guess, that NDCAP would be a good venue through which to release that information. So does that feel okay? And if something changes, that's fine. We'll accommodate it. And then the other thing is we'll convene the Issues Committee at least once before that meeting. If nothing else, just to bring to the panel initial ideas, initial thoughts, initial discussions for us to begin the process as far as issues, topics that the panel needs to discuss. And then we'll also need to figure out generally what the meeting schedule is going to be for the year. Statute requires that we meet at a minimum of 4 times a year, and we can meet more frequently. But by then, hopefully by May, things will be getting underway at the plant, or I know they're already kind of underway, but I think everybody will have a better feel for what's coming. And so we'll flesh out the agenda in more detail in the months ahead. So does it sound okay, like an okay approach? Yes. Okay. All right. Can I get a motion to adjourn? Thank you. All right. Thank you all. Thanks for coming out tonight.